Hello and welcome to this special pop-up pro bono partnership of Atlanta webcast. I'm Sarisha Gunta, Education Director with PBPA. And today, let's take a brief pause from the roller coaster that has been the past 6 weeks to talk about immigration and how nonprofits can prepare for the enforcement priorities of the new presidential administration. There's a lot that nonprofits have to navigate now, and Robert Lee is here to speak with us today about what is going on in immigration enforcement and what nonprofits can do to try to prepare. I'd like to first introduce our speaker, Robert Lee. He's a partner with Troutman Pepper Locke here in Atlanta. His practice focuses on business immigration matters for employers, and he has been recognized by Best Lawyers in America, Immigration Law, for several years. And our PBPA nonprofit clients don't often have immigration matters come up, but when they do, Robert has been a PBPA volunteer directly advising our nonprofit clients as well. But before Robert gets into the substance of today's presentation, I would like to share a bit about our mission at the Pro Bono Partnership of Atlanta. PBPA provides free business legal services to Atlanta area nonprofits. We connect small community-based nonprofits with volunteer attorneys from law firms and corporations across Atlanta and the state of Georgia. PBPA provides legal insight relevant to small Georgia nonprofits, striving to meet nonprofits wherever they are in their journey and capacity. Our Learning Center has curated podcasts, webcasts, and articles, and these are available to anyone for free and are tailored specifically to small Georgia nonprofits. If you have a legal question, you can probably find an answer there. And a little bit about our clients. Our clients are 501c3 organizations serving the Metro Atlanta area or based in the Metro Atlanta area. Their focus is on low-income or disadvantaged individuals. Our clients are otherwise unable to afford legal services and employ at least one paid staff member. If you are interested in learning more about applying to become a client, you can go to our website at that link in the slide and get more information there. And now for a little bit of housekeeping. This webcast is copyrighted. We welcome your general questions during this presentation. You can type them up in the Q&A, and Robert will try to address them by the end of the presentation. But please keep in mind, only share general information in your questions, and this is not legal advice. Please reach out directly to an attorney if you need to discuss specific concerns for your organization. For your general questions today, as I mentioned, you can use the Q&A feature to pose questions to Robert. We have a lot to cover today, but we will strive to answer all the questions by the end of the program. I will share today's slides in the chat momentarily, and this presentation is also being recorded. So the slides and the recording will be available on our next site in a couple of days. And now, to get to the substance of today's presentation. Robert, I know that your already busy practice has only gotten busier recently. So we really appreciate you taking this time to speak with us today.
Sure. Thank you for that introduction, and thank you, Sarisha, for all you do and for all the PBPA does. Happy to be with you today. Thanks. Again, my name is Robert J. Lee. I'm a partner with Troutman Pepper Locke here in Atlanta. And so we're going to be discussing navigating the new immigration landscape under Trump 2.0, as we call it. And following up on what Sarisha was saying, if you have questions, please type them up in the Q&A box, and we'll try certainly to answer those as best we can, given the time constraints. So as we know, Trump he made immigration and immigration enforcement a key part of his 2024 campaign. And as we've seen over the past 6 weeks, his administration is following through on that, from the ICE raids and mass deportation, rescinding TPS extensions, and suspending the parole programs, those benefits. So gaming out his immigration agenda for the new administration, the key questions are going to be, what resistance does he face? Does this administration face from budgetary limitations, legal challenges, and legislative opposition? So, as you can see from the agenda, we have a limited scope today. We're not going to tackle every aspect of immigration. There's just not enough time. So we're going to focus on increased worksite enforcement actions and raids, managing work authorization gaps for employees who have temporary work authorization, changes to the humanitarian programs for which or through which your employees might have their work authorization, and then anticipated additional changes that we might face. We're not going to be addressing things like individual immigration issues, such as asylum applications or family-based visa sponsorship, or individual protections for undocumented workers. This is just limited to what nonprofits as employers should be aware of and get their arms around. As Sarisha mentioned, this webinar is not legal advice. So what we're talking about is also hopefully up to date as things can change even during the next hour as we're seeing things happen fast. So keep that in mind, as we move forward through this. Okay, so when we look at Trump's immigration priorities, we start with his promise that he is going to conduct the largest deportation program of undocumented immigrants. So starting there, let's look at the increased worksite enforcement actions. So those enforcement actions take several forms. The inspections or audits, looking at the Form I-9 for employees, the investigations, the government inquiry through the Fraud Detection and National Security Department into specific individual employees under immigration sponsorship, and then the newsworthy, the dramatic raids that the administration is seeking to carry out. So let's start with inspections with the I-9s. And on that topic, we have our first poll question, which is E-Verify. So is your organization enrolled in E-Verify? Go ahead and click the proper button, and we'll see what happens here. Just so you know, there are state level requirements for E-Verify. So I don't want anybody to panic, but this is something that people need to be aware of. So let's see what happens. So basically, to go over what E-Verify means, that is the okay. Here we go. So we have 76% are registered with E-Verify. No, it's not required for 1, and then 3 organizations are not familiar with E-Verify. So E-Verify is the federal employment verification program. And for the state of Georgia, even though it's a federal program, a lot of states have instituted requirements for employers of a certain type or a certain size to register with E-Verify. And in Georgia, the E-Verify law requires employers to enroll in E-Verify if the business has 10 or more full-time or full-time equivalent employees, or if the organization has a qualifying public contract, a contract with the city, the state, county, the school board. So although registering with E-Verify, obviously for the organizations that are required to do so, it does create additional options for working through the I-9 compliance and providing safe harbor. But if you're not required to register, then there are pros and cons to doing so. So with that in mind, let's back up and talk about the I-9 and the I-9 audit process in general. So the I-9, hopefully everybody knows that it's the employment eligibility verification form. I believe all of the PBPA clients have at least one employee. So all of you should have at least one I-9 on file. So this is critical for everybody. Homeland Security Investigations, HSI, is the division within ICE that handles the I-9 audits nationwide. Trump has obviously indicated that he wants to pursue these types of audits, these types of enforcement actions. With respect to prior administrations, during the Bush and Obama administrations, they conducted an average of 3,000 to 3,500 audits a year. And during the Biden administration, less than 1,000 averaged it out. During Trump's first term, he conducted almost 6,000 in 2018, almost 6,500 in 2019, and in 2020, they set a goal of conducting 12 to 15,000 I-9 audits. So obviously, COVID interrupted that sort of enforcement action, but we certainly expect these audits to ramp up again in his second term. So now, in terms of the industries that he could be targeting, that the administration could target, you look at hospitality, agricultural, seasonal hiring, retail, and construction are the big ones that have seen these types of increased enforcement actions, and for highly regulated industries as well. Given the additional requirements and rules, then they want to, then it's low-hanging fruit, so to speak, oil and gas, healthcare, transportation, federal contractors, organizations that are related to those industries. So, depending on the type of assistance or the type of clients that your nonprofit serves, then there might or might not be an increased risk. All employers can potentially be the subject of an audit, so it's just something to keep in mind, whether or not you are potentially at increased risk. Now, why is it important to anticipate and prepare for an audit? So the current I-9, it's evolved over the years, and the current version of the I-9 is one page, right? How hard could it be, right? So the handbook for the form itself, it's called the M274 Handbook for Employers, that has over 100 pages on how to complete a one-page form. So it's really easy to do things wrong, and not out of anything other than the rules are complicated. So it's easy to to have errors on a one-page form, and so with the fees that can be imposed and the fines, the penalties for violations. In January, the fees increased for the violations from they can range from for the violations each a low end of $288 up to $2,861, depending on how many violations, how many employees, and things of that. Those are the considerations that they look at. And so, in addition to that, if you have a violation where the organization knowingly hired, recruited, or retained an unauthorized worker, then that can go up from $716 to $28,000 just for that violation. So it's really important, it's critical that employers have their I-9s in order, and for those fines and for those violations, it can be it could potentially be devastating. So those are the reasons. It's something that anticipating and preparing for it. All organizations need to do this. So as I mentioned, yes, yeah.
I have a quick question about those I-9s. So
Yeah, please.
when an employer gets an I-9 from their employee, from a new employee, should they file that away with the rest of their HR documents, like their performance reviews and all that, or should they keep those in a separate place?
That's a great question, Sarisha. Those should be kept separate. They aren't really considered part of the employee's personnel file. And especially if there is an audit, then the organization typically has 3 days to respond and provide the requested documentation. So having the I-9s separate is it just makes it that much easier to respond. So our recommendation is for the organization to keep all the I-9s separate from personnel files and essentially have an I-9 database that holds them all. If that makes sense. So with returning to the I-9 document itself. So as we're looking at these requirements, right, then the specific requirements where the employee has to complete the section 1, that's their name, their birth date, all of that information that that has to be completed no later than day 1, than their date of hire. The employer has to complete and sign section 2 within the 3 business days of the date of hire. And section 2 is where the representative of the organization completes the I-9 by reviewing the documentation that proves the identity and work authorization. And so, with that, and that's where a lot of the errors can happen, both from the timing perspective and as well as, just the mechanics of completing the form. So for those of you, for those organizations that are registered with E-Verify, you're eligible to use the alternative document review method, where you can do this remotely. The employee or the new hire has to forward copies of the document, and then you have to get on a live video where they present the document, and but you can complete it that way. In this age of remote work, then that can really make things a lot easier if you are E-Verify registered. It's not necessarily the only reason to register for E-Verify, right? So again, there are pros and cons to registering with E-Verify. So, but again, if the state requires you to do that, then obviously you have to comply with that requirement. So let's move on to the next slide. Okay, and this is this information is critical in terms of how to prepare for that potential inspection or audit. The first is, have someone who's familiar with the requirements. Take a look at all your organization's I-9s. Depending on the size of the organization, that could take an afternoon or it could take a week. But given the penalties and the potential for inspections and audits, then this is going to be critical. So review them for completeness, right? So just to make sure that all the spaces that need to be filled out are filled out, that they're all completed. Make sure that the information is correct, certainly. And then one critical overlooked requirement is that the Form I-9 itself is kept on file as long as it needs to be kept. Right, so if you've got someone, the regulations require that you have to have an I-9 on file for every employee, and you have to keep that I-9 on file for either 3 years after the date of hire, or for at least 1 year after the date their employment ends, whichever is later. So just because someone resigns or they get fired, you still have to keep that I-9 on file. Now, after that, once you're done with that retention period, then it absolutely makes sense to get rid of those I-9s. And the reason is if there is an audit, if there is an inspection, and there are errors or violations on those forms, then there's no need to provide that to the government if you don't have to. right? So it's a good idea to, periodically review those to make sure that you have only what you need in that file. So another concern or another requirement that employers sometimes lose sight of is that the version of the I-9 that they're using can expire, right? So we've had clients where they just keep they printed out a master I-9 from 2010, and they just keep a copy of that, keep it blank in their files, and then as they hire new folks, and they just make a copy of that 2010 I-9. That version expired in 2011 or 2012, right? So you need to go to the USCIS website and make sure that the I-9 version that you're using is the valid version of the form. And when you're going through your I-9 audit, and you're looking at the date of hire and then the version of that I-9, and then that's something to keep in mind too, right? To see that when we hired this guy in 2017, we used the 2010 version of the form. So, it's probably a good idea to download the version of the form that was appropriate, if available, or at least acknowledge that, we discovered this error, and this is what we're doing to correct it. And when you go through the I-9s, then you can make corrections. If there's the zip code was incorrect, or the format of the date, instead of month, day, year, it was day, month, year, or something like that. You can draw a line through it. Do not use correction fluid or otherwise obscure what it originally said, but make that correction as you're going through those. So these are just to make sure that you're showing, if there is an audit and you turn this documentation over to the government, then there is an effort to a good faith effort to be compliant with these regulations. Okay, so while we're doing that, sorry, let's go back one. Sorry, thank you. So now when you're going through your audit, then also be sure to consider the company's policy around the I-9, the document retention, whether it's copies both of the valid I-9s, but also the employment authorization document that the company that the employee provides. It can be with the exceptions for certain E-Verify documents, you don't have to keep their employment authorization documentation, that they show for as to establish their work authorization. So, but if you do keep copies if you either have to keep copies for everybody or for nobody, essentially is the requirement there. And it's also a good idea to conduct periodic self audits. Again, when you look at the just to make sure that everybody, your HR representatives are still are doing things correctly. And then it's a good practice to have a second set of eyes look at it after it's completed to make sure that it's correct. It should also have systematic reminders about both purging the expired I-9s and then to re-verify the employees who have temporary work authorization. So all these things that you can put in place to make sure that if there is an audit, that you don't have a lot of correcting or a lot of fixing to do, and that you can be confident that your documentation is proper. And then, as I mentioned earlier, if an employer receives a notice of inspection from ICE, then then the employer is allowed 3 days to prepare and transmit that documentation. We've had clients who let us know after the fact, after they've been imposed a fine, where they say, "Hey, can you do something about this fine for this I-9 inspection that we didn't know about that happened 6 months earlier?" And so if you have an inspection, and don't just box up the I-9s and send them out, right? Be sure use those 3 days that you're allowed to have and review those documents. And if you need to seek counsel, then do that within those 3 days. The investigators in the past certainly have been somewhat flexible and say, hey, our HR manager is on vacation, or we're in between, the benefits people, and so we just can we get an extra few days to comply? A lot of times they're reasonable and they allow you to do that. So okay, so we can move on from there. Let's now probably be a good time for questions about the I-9s.
Yeah,
So let's take a look.
we have a few of them. You mentioned this, but can you say again, how long do you need to keep I-9s on file for
Yes.
employees after they've left?
So you have to have an I-9 on file for every single employee that's currently employed. Beyond that, then the documents have to be retained either 3 years after their date of hire, or for 1 year after their employment ended, whichever's later. So if you hire someone on January 1st, 2025, and they resign on January 2nd, for whatever reason, they resign the very next day, then you still have to keep that I-9 for 3 years beyond the date that they were hired. If they stay on board until January 2nd, 2028, then you would keep it on file for at least a year. So until January 2029. So it just depends on how long they work for the organization, and you would calculate it from there.
And do you need to re-up the I-9s if you have an employee who has been with you, say, since 2015 or 2010? Do you need to have them refreshed?
No, so for employees who are U.S. permanent residents or citizens, and on that section 1 of the I-9, then that's where they indicate what classification they are. You don't have to re-verify them for at all. So if you have somebody who shows a U.S. passport, if on the date that they're hired, the date that they complete the I-9, if their passport expires a month later, then you don't have to re-verify them because they have, essentially what's permanent work authorization in the US as a US citizen. So even if the document that they use expires, US citizens and permanent residents don't have to, you don't have to re-verify them. So, but for individuals with temporary work authorization, whether it's an EAD, which we'll talk about later, then those are the folks that you have to re-verify. And that has to be done prior to the expiration of the document that shows when their work authorization expires.
Okay. And what about, we have a couple people asking about contractors. Do they need, if working with independent contractors, do they need I-9s, or do they need a copy of some sort of work authorization document?
So that's a great question, and there's not a good answer for that. The very brief answer, and it's not the only answer, but the very brief answer is no. If you have a contractor and they're not a W-2 employee and they're paid via 1099, or if you contract with an external agency that they're an employee of, then the no I-9 is required for that individual. It can get into what are called employee or employment classification questions. So if you have someone who you're paying 1099, but they report to work at your work site, they receive direction from from an employee of your organization, and for all intents and purposes, they act as an employee of your organization, except for the name on the name on the paycheck, then that can raise concerns about whether or not the person A is properly classified as an employee or a contractor, and then B, if that person would be considered, if it would be essentially a co-employment situation. And if that's the case, then that can raise questions about whether or not they're truly a contractor, and if you needed to have an I-9 for them anyway. One tangent or one related question from that is, we have potential clients. We've had folks just inquire about, saying that, well, this person, they applied for a job, they didn't have work authorization, so I told them to go get a job with this contractor, and then we would, have them come join us. That's not allowed because that's knowledge, right, that the person does not have work authorization. So if that happens and there's an audit, whether it's of your organization or the contractor, ostensibly that was providing the services, then the organization could be considered a co-employer and also liable for that violation of employing someone who does not have work authorization. So it's critical that that you do pay attention to those restrictions and requirements in terms of who is the employer, are they properly a contractor, and questions like that.
Okay, thank you, Robert. There's other questions, but in the interest of time, I'll save those till the end if we do have time.
Okay. Okay, yeah, I'm happy to answer those questions. So I expect that we'll have time. So but so we can move on to the investigations, right, as opposed to the inspections and audits and then the raids. I'll just briefly talk about this. The investigations conducted by Fraud Detection and National Security Division within USCIS, that's really for specific employees that are being sponsored by an employer, which I don't think is relevant in this discussion, but I'll just mention it briefly, just in case. And that is when a petition, like say for an H-1 or an L-1, when that's filed with the government, then the employer essentially agrees to allow immigration to make a site visit to confirm that the beneficiary, the employee, is being employed under the terms of that petition that was filed. So for anybody who has an H-1B employee working for them, then the person at the front desk essentially needs to know that, hey, there could be an investigator coming to check up on this employee. So then in larger organizations, that can sometimes be a problem because if you've got 500 employees at a location, then the front desk person might not know every single person that's working there. So it's important to specifically point out to the receptionist, to the front desk people, that here are the however many H-1 employees that we have here. If USCIS asks about them, then you can page them to come here, or if they're on vacation, or whatever the situation is, just to make sure to avoid questions or issues. Or if you have a receptionist who doesn't know that person's there, then the inspector could go back, write up a report, and says that there's no record of this person working at this location. This is a violation, and so we're going to have to we're going to revoke this approval if that happens. So again, that's just wanted to mention that as another type of workplace enforcement. So okay, so let's move on. All right, next poll. And this poll is, with all this talk about worksite raids and enforcement actions, then I believe we want to take your temperature on how worried are you about these raids?
Oh, there we go.
I'll give you a few minutes to respond. Keeping in mind, of course, that certain industries, certain areas have been targeted, but let's see what let's see how you all feel. Okay, All right, looks like about a third think it's likely, and 2/3 are it's not worried about, and then 4 folks not worried about it at all, which is I think it's when we're talking about these types of concerns, it is again just in general with the increased emphasis on enforcement, then it is it's more likely than it used to be, certainly, but the specifics of each organization, it's just going to depend on the industry, as we were talking about before, in the area. Um, as we've seen over the past 6 weeks, that there is, in Newark, Chicago, Denver, these big cities with significant immigrant populations, then that was the big splashy show of these raids that they wanted to accomplish. Um, when we're what we've seen recently, they've gone to housing developments, construction sites, restaurants, and now they are going to churches and at least having some presence by schools as well, which is obviously concerning on many levels. Um, the focus has initially was to remove undocumented workers that have criminal convictions, but now the administration is essentially backdoor expanding what it means to be a criminal, right? And their new definition is that somebody who came here without authorization or is working without authorization, that's a crime. So they're also considered criminals now. So they're also the new administration is now picking up folks who happen to be at the location, even if they were targeting a certain individual. If there are other folks in that same situation, then the enforcement folks are now picking those folks up as well. So it's certainly a fraught time for all. And during the first term, they were looking at specifically the manufacturing and the meat and the poultry processing, making a big show in the Southeast, certainly in the Midwest. And when you look at who should be on alert, as we just discussed, really organizations that have jobs that are hard to fill, there have been expanded enforcement actions, say in the agricultural industry, certainly in California, and then as I mentioned, just they've abandoned a Biden era self-restriction on staying away from sensitive areas, churches, houses of worship, healthcare facilities, and schools. That's gone now. There's litigation pretty much surrounding every aspect that we're going to talk about today. So these situations are fluid, but as of now, there was a recent lawsuit preventing them from going into houses of worship. It was limited to those particular litigants, but we'll see what happens as these things go up on appeal and as other lawsuits are brought. So, okay, so let's go on and let's talk about how employers should prepare for these raids. The most important thing is to have a plan, just to be prepared for this. Whether you are in a potentially targeted industry or not, I think that it is super important that you have that you have a process in place for if and when this happens. I've linked basically it's a really good guide from the National Immigration Law Center for putting together this type of plan. I'm just going to highlight the important parts of it, which is to the first line of defense, if you will, again, is the receptionist, the front desk person. They're your organization might have a 19-year-old college freshman at the front desk, or it could be a you know, someone who's been at it for 30 years, so it's, keeping that in mind as to who is going to receive the investigators. It's important to train them up to make sure that they know what they're doing if this happens, if there is a raid. Um, One of the important, for that front desk person, ask for ID, ask to see the documentation that they're saying that they have to come in for this. One of the more important things is distinguishing between public and private areas, right? So as an organization, as a business that's likely open to the public, then that there are certain areas where the public can come in, and there are certain areas that are private. So make sure that that is clear. Doing things even like putting up signs saying private, like beyond this desk or through this door is private, right? Or even locking certain areas, keeping things off limits, and making it clear what the distinction is between public and private areas. The next most important thing, which can be tricky for someone dealing with folks with badges and guns, right, is asking to see the warrant and making sure that the warrant is what it says it is. If they have, the agents will likely show a piece of paper, say this is a warrant, but there's a distinction between a judicial warrant and an administrative warrant. So a judicial warrant, absolutely, right? The business has to comply with the terms of the warrant. So that's a formal written order signed by a judge. It's issued by a judicial court, right? There's still limits within it, but if they have a judicial warrant, then the agents can go into the private areas in pursuit of the particular individual or individuals that are listed. An administrative warrant issued by an ICE agent or DHS itself, that does not allow the agents to go into the private areas, right? So typically an administrative warrant is on the form I-200 or I-205, right? So that does not require compliance. An organization does not have to let agents in with an administrative warrant. So, if it is a judicial warrant even, and the agents come in, then be sure to the extent possible, monitor what they're doing, right? If the front desk person, has a manager or somebody, as the first call, that they make, then it's important that the organization, again, to the extent possible, stand firm in terms of what their limitations are. If it's an administrative warrant, this is private, you can't go back there. If it's a judicial warrant and it says we're looking for this person and they start asking about other employees, right, then that's, this is outside of the scope of this warrant, right? So it can be very intimidating. It can be very difficult to deal with, but that is, that can be, but that's important to do that as best you can. And then if they do, if you can record it or if you have security cameras that are monitoring them, that's great. And then, if they do connect with somebody and they detain them, then if possible, ask where they're being taken, right? They need to be, the loved ones need to be notified. And, if there are, kids who aren't, when they get home from school, maybe, that their family's not there, then so things like that need to be addressed if possible. So develop the plan, rehearse the plan, just to make sure that that these things are, that your organization is ready for something like this. And then, in terms of, in terms of the individual employees, then there's, you can provide what's called a red card. I'm sure most people have heard about the red card. There's a link there to the same organization that provides red cards that lists their rights as as the immigrant, if you will. So and it's things like, I'm not going to answer any questions. I want to speak to a lawyer. That type of thing that that folks can use. So that's again, that's the very brief overview of how to prepare for these potential raids. Um, and I think we can maybe address questions now if there are any related to this topic.
Yeah, one question I have is, you mentioned judicial warrants versus administrative warrants. If the individual working at the front desks asks for documentation and they see a piece of paper, how are they supposed to know
Well, it's that
which one it is?
I mean, they will need to the extent possible, right? They need to look at the document, look at who signed it, and look at who it was issued by, right? And then and they also, I think they can certainly make a copy of it, or they should be at least, you know, attempts to make a copy of it.
Mhm.
But a judicial warrant is going to be issued by a court, whether it's district court or state court, magistrate, and then signed by a judge. The administrative warrant, again, it's going to be issued by DHS and signed by an officer or an agent. It won't, it might even be signed by an immigration judge. But even if it's signed by an immigration judge, and not a state court judge or another kind of judge, it could still be an administrative warrant. So the administrative warrant, they can look at there will be a form number. If it's on an I-200 or an I-205, then that's going to be an administrative warrant, and they don't have to comply with that. The employees need to be calm and respectful, saying, this is administrative warrant, we can't let you back into these private areas or things like that. So, but it's, again, I acknowledge it's a lot of pressure on, on the front desk person who, it's like, I'm here to answer phones. I'm not, here to talk to, agents, who are coming in looking for somebody. But it is something to keep in mind, because it's, again, it can happen.
Okay. And if they come to your office and they ask questions, if they have a judicial warrant, do you have to answer the question?
You can, I mean, you can't get in their way, right?
Okay.
You can't, block them from, doing their investigation. But if they're asking, is this person working here today? Then I think that I don't think they have to answer the question. Um, so I think that don't quote me on that. I think that there is still the right to remain silent and things like that when being questioned. If they're responding, then they can't lie, right? They can't say that, but they can't provide false information. But I believe they're still within their rights to provide no information. So I can follow that up, because I think that that's probably an important question to get right. So, yeah.
And this other question, it might actually be a segue into the next section that you're going to be talking about.
Mhm.
But they're wondering if during an ICE raid, would organization need to be just concerned about undocumented employees, or could an ICE raid also cover humanitarian parolees or TPS individuals?
I mean, that's a great question. Ideally, if somebody shows that they have status, right, or if they're here in an authorized period of stay, then they shouldn't be worried. I think that we've seen, at least anecdotally, where agents will stop and question all the non-white employees, right? And so that there could be some, I guess, period of detainment, right, where they're being questioned or things like that. But these are these aren't surgically precise raids, right? These are sledgehammers, and so for individuals who do have authorization, whether it's through TPS or one of the other statuses, then they should not expect to be caught up in this. But it's possible that they will be. There have been examples of that happening. And so, Puerto Rican folks have been detained and brought to a detention facility. And then, hours later, the officer realizes that Puerto Rico is part of the US. And so they say, oh, sorry. And then they let them go. So, I mean, it's possible that that folks with that type of status could be, caught up in it, but technically they should not. They shouldn't be. I wish I could give a better answer than that, but mistakes can be made, whether it's an intentional mistake or not. But that can happen.
And one more question on this section before going on to the next. Going back to talking about administrative warrants. Just to clarify, if someone does come, the law enforcement comes with an administrative warrant, you don't have to necessarily let them in at that moment, but you still have to provide whatever information is being requested, right? You just don't have to let them in the building?
No, you don't have to provide, you as an employer aren't required to like, compliance is not required on an administrative warrant. So if if the individual that they're looking for is getting off their shift at that point and they happen to walk out, then there's nothing you can do to stop them, right? If they walk out in a public area, but there isn't a requirement, to answer questions, on an administrative warrant. So.
Okay, thank you.
So, yeah. Just realize that we are taking up a bit of time on these topics. So, I wonder if we just, in terms of the utility for this discussion, maybe let's, given it's 1:52, maybe we should skip to the humanitarian, the changes to the humanitarian programs. And I'll just do this briefly because I think that there's, obviously, a lot of questions about the I-9s and things like that I would love to return to. So we'll just go over this briefly in terms of the humanitarian programs. So, even if you don't have employees that you're sponsoring for immigration status, then, as mentioned earlier, you could still have employees that have temporary work authorization. And if that's the case, then it's potentially through one of these humanitarian programs. So let's take a look at the next slide. So one of the common humanitarian programs are parole programs, family reunification, and Uniting for Ukraine, which for the folks who were victims essentially of the Russian invasion, that program, both those programs have been suspended basically. So you do have people who have already come in and are in this parole, and but they're not accepting new applications for these programs, and they're not only that, but for the folks who are already here and who are applying to extend things like work authorization, they've suspended the processing of those applications as well. So you have these folks in this parole status who are essentially in limbo for a while. We would still certainly advise them to continue to file their renewal applications, because it's not clear whether they're going to resume processing or if they're going to end the program entirely. But at least if to the extent that they can submit renewal applications, go ahead and do that, just to preserve at least the intention to maintain that authorization to stay. So let's okay, next slide. TPS, temporary protected status. I'll try and hustle through this, but basically TPS is for individuals from countries that have experienced things like natural disasters, political instability, or armed conflict. So, these are designated by the Secretary of Homeland Security, and, these could go on forever, or for a long time, even though it's called temporary protected status. Um, so, that's really at the discretion of Homeland Security. And so, last month, the Biden administration extended TPS designations for multiple countries, but for whatever reason, the animosity to both Venezuela and Haiti, the new administration has rescinded the extension of the TPS designation. So you have folks who were employed, who were able to stay, for example, through 2026, I think, for Venezuela, that's been rescinded. So now their status, their TPS designation is either going to expire in April or in September, depending on which program they're here with. For Haiti, this just came through in the past week or so. They had originally extended it through February 2026, but Secretary Nome rescinded that extension. And so now their TPS is going to end in August of this year. And for folks who are in TPS, if the TPS designation has not been extended, then they will need to either find a new status that they can change status to, or they're going to have to depart the US, or else they will be unlawfully present and likely subject to deportation. So, okay, next slide. And then DACA, Deferred Action for Childhood Arrivals. I know this is very important for a lot of people. And Trump has his, it's got a target on its back, basically. And the first Trump administration tried to end that program. And there are various, numerous lawsuits made it all the way up to the Supreme Court to say that his attempt to end the program was arbitrary and capricious, everyone's favorite legal standard. So if it's certainly on the chopping block again, and the expectation is that he's going to do it, or the administration's going to end it properly this time. So I think for folks in that program with that designation, then they need to be prepared for that to end. Okay, so next slide. Okay, so for these humanitarian programs, again, when you're auditing your I-9s, then review the categories for the folks who have temporary work authorization as a non-citizen or as a non-US worker. Then pay attention to that and see what they are. See if they have anything else available to them. If they can, if it is a TPS designation, be sure to apply to extend their work authorization as early as possible. Is typically the filing window is 180 days from the expiration. It's important that they do that because some classifications do not have the benefit of automatic authorization, automatic extension while the applications are pending. So, for critical employees, there could be some alternative visa classifications. If you've got somebody who's been working here for 20 years as a Honduran national, for example, through TPS, then maybe you can pursue, a green card for them through labor certification. Just briefly, as nonprofit organizations, then there are potentially eligibilities for a CAP exempt H1. If the nonprofit is formally affiliated with a university or a college, or if it's a nonprofit research organization. So those are options for critical employees as well. Okay, there was 159. So let's take a look at the next slide. Yep. Just a quick overview of the potential changes. Well, Sarisha, should we address questions or should we go through this first?
I think we can go through this first.
Okay. Okay, just briefly, the expanded enforcement, as we're talking about, not only are they going to houses of worship and schools and healthcare facilities, they're also looking at tracking down unaccompanied children. The hundreds of thousands that made their entry without their parents, and so they want to track those folks down. If there were an immigration court filing or a court order, notice of appearance to get processed, and that they just haven't either showed up or for whatever reason, that's a group that they're looking at targeting. And then as well as the suspension of legal representation to the accompanied migrant children. That was they suspended earlier, lawsuits turned that around, so they're now providing the allowing that legal support to those kids. I mentioned briefly about the potential about the automatic employment authorization extension. That's for individuals who have the temporary work authorization. Certain categories are given automatic extensions of their work authorization while the extensions are pending. Right now, it's at 540 days for those certain categories. Probably going to roll that back to the previous 180-day extension. And then, of course, we've all heard about the birthright citizenship. That's still in litigation. That's going on. And then, just briefly, for your employees who are foreign nationals and who are looking at traveling abroad, then recommend caution, certainly in terms of both where they're potentially traveling and how long they're going to be gone. It's we certainly anticipate the State Department instituting a travel ban. Just based on the previous administration, what they did during the first time. So. Potentially incorporated now in addition to the Iran, North Korea, and those countries, then potentially some other African and South American countries as well. We'll probably get a sense of that maybe in the next month or so as to what they're going to come up with. And then just one more thing. Things are going to take longer and things are going to be harder. All right. And so if you have employees or clients even who are planning on traveling and applying for benefits, it's just going to, the staffing is going to drop, and the resources devoted to processing benefits, those resources are going to shift in favor of enforcement and removal. So just be prepared for longer wait times for things. So we're over time, but I'm happy to stay on, Sarisha, if that's
Great.
answer questions.
Yes, I do have two other I-9 questions for you, and then I think it would be great to go through your kind of your recap slide.
Sure.
One of the questions is a couple of people have said they have to use a vendor, third-party vendor like QuickBooks for their I-9s. And on there it says electronic signature on file for the I-9. Is that okay, or should a wet signature be collected on the?
That's fine now. So there are certain requirements that electronic I-9s need to meet, and but electronic signatures, that's fine if it's done electronically and they just type their name or click on the I'm signing this, then that's acceptable. So I don't think that in and of itself is not a violation. So.
Good. And then one attendee is asking, would it make sense to request fresh I-9s and associated documents from all employees across the entire agency, just to make sure we have all our ducks in a row?
So I would counsel against that, against such I think that if there can be what's called over documentation. So if you have an organization that's that does that for everybody. It's, although it's even-handed, for the individuals who already provided, valid documentation, then, arguably that could be considered as a overreach. I think it's a better use of time and resources to do the the audit of the forms. And then for the ones that aren't up to snuff, then to pursue corrections that way. I just think that you may run into more trouble by having everybody, um, even individuals who have, facially valid I-9s redo it. So I wouldn't recommend that.
Okay, I think that's it for questions for now, so.
Okay. Okay. So briefly, then let's, we can recap and talk about, just as I was just saying, review the documentation, make the corrections that are needed. If there's if an I-9 was completed a day late, don't go back in, scratch out the date and write in the correct date, or not the correct date, but, a compliant date. If something is done late, then you just have to accept that. But for blanks that were left empty, or if things weren't signed, or if the wrong document number was listed, then you can make those corrections. So definitely go ahead and do that. And then when we're talking about preparing for raids or for inspections, investigations, come up with a plan. Talk to make sure that the people at the front desk know exactly what they have to do. Rehearse that plan, just to help get them comfortable with this if this happens. When you have an organization who knows what they're doing, right, then the investigations people that come in, there's a certain level of, not formal, but there is a certain level of respect, and they're not going to walk all over they're not going to overreach, just because they can. So, and then, again, just apply early. We didn't talk much about the H1 and the L1, but especially for the employment authorization documents, if you're not directly sponsoring your employees, but the employees are relying on those EADs, then feel free. Like when you have, when you go through your I-9s, then note that down and make sure that those employees are being reminded to process those extensions. Again, 180 days is the outside time frame for that. So be sure to remind them of that. Share that responsibility with the employee. So if you have folks who are, when they come in and they say, yeah, as long as I get it in the door before it expires, then it's fine. It's not. It can be, but it's always, it's better to file it early. Again, look at, if you've got essential critical workers, who are in this temporary protected status or other statuses, look at these alternative visa classifications. If they're a citizen of Mexico or Canada, and they have DACA or something like that, then look at maybe pursuing a TN or another type of employment-based visa. Again, limit non-essential travel abroad. If you have someone who's here if they're working as a student, right, pursuant to practical training, which is a type of work authorization for recent graduates. If they have on their social media, they say, look what we did, and it's like, I made $200 working security at this concert, it was great, then that's working without authorization, so that doesn't comply with the requirements for their F1 visa. And so for anybody who's traveling, then the social media is a particularly dangerous trap, because agents and Customs and Border Protection can look at all that, and they do look at all that. So just advise your employees appropriately to make sure that what they're posting and what they're putting out in the public is consistent with what their immigration status requires. And then the last thing is don't give the government an easy reason to deny your request. If you've got somebody who's applying to extend their EAD and they forget to include their photos, or if they list the wrong, birth date, or they're just not careful in terms of what they prepare and file, then that's that's an easy delay or an easy denial, for for this application. They can take 6 months to process a renewal application. And then if they tick the wrong box and say that this is my, I'm category C8 instead of C9 or whatever, they could be waiting 6 or 7 months and then have it be denied. So just really encourage your employees to be careful with what they file. Yeah, just be prepared. So that's the takeaway, I guess. I'm happy to answer any last minute questions. I know we're 10 minutes over, so.
Robert, I will say, kind of in the vein of be prepared, I will highlight document retention policies. We generally advise that all our nonprofits have a document retention policy on your 990. That's one of the 3 policies that the IRS specifically asks about. And now here's another reason to make sure you have a good document retention policy to help employers kind of keep track of what documents they have and how long to keep them. Because as important as it is to have all these forms on hand, it's also important to get rid of them at the appropriate time, consistently, not randomly, because if you just do it randomly, that's one of those things that could raise a red flag and look a little suspicious. So just to help with consistency.
Yes, yeah, absolutely. I wholeheartedly agree. So when you're doing your I-9s or when you're looking at your I-9s, and make sure that you periodically call the ones that are expired, and it's just overall it's better for the organization. So
yeah.
Yep.
Robert, this is great information. Thank you so much for sharing all of this with us today. To our audience, thank you so much for joining us and the great questions. I know you have a lot to do, a lot to navigate, and I love that you're taking the time to ensure your preparation and compliance for whatever might be coming down the road. And thank you so much to Robert for sharing your time and expertise with us. A quick note to our listeners, when you close out on Zoom, a survey will pop up. We really would appreciate it if you could share your feedback with us, because we really do look at it and we really do value your feedback. So thank you, everyone. And that's it for this special installment of the Pro Bono Partnership of Atlanta's webcast series.
Thank you.